Good morning. Good afternoon, everyone. We're just giving everyone a few minutes to load in. Thank you for your patience in getting over 2,000 people into this webinar today, which is very exciting. All right, so good afternoon or morning, wherever you are now, and a big welcome to ATICSA members on today's webinar, and also to our sister association NBIDA's members who are attending today. Thank you also to the press and media who are joining to understand the NPRM and the process therein, and to our many registrants from various levels of state and federal governments. We have also the leadership and the members from the Association of Governing Boards for Universities and Colleges, the School Superintendent Association, and the Association of Student Affairs and Catholic Colleges and Universities joining us today. We value our relationships with these partners and welcome. And lastly, thank you to the greater ATICSA community and TNG's clients and those attendees who may be new to us, and for joining us to learn together as we embark on another time of great change in the field of Title IX. Now, I would like to just go over a few things. For the Zoom etiquette, this program is being recorded, and the recording will be on your event lobby and in our resource page of our website within 24 hours. If you have a question, you can utilize the raise hand feature if we have time for Q&A, and we will be more than happy to go through that. And I also want to let everyone know about our next webinar for the NPRM process, and that is one that's solely focused on K through 12. That will be July 6th from 1 to 2 p.m. Eastern Time. And be sure to visit our page that will take you through this process, as well as the proposed regulations, the final rule, and implementation at aticsa.org/regs. Thank you so much, and I'd love to turn it over to Brett, who will introduce us.
Thank you. It is great to have so many of you with us. I see you all checking in on the chat. It's like a geography bee. We get to see people from all over the country. I even know the temperature in Houston today. Thank you for weighing in. And we have an opportunity to talk about the proposed rule. This is an overview, right? We're not here to dig into the deep details. There will be plenty of opportunities for that throughout the summer and as the final rule progresses toward becoming, or as the proposed rule progresses toward becoming a final rule. But we really want to give you a treatment today of some of the important topics that we think are worth paying attention to. I also want to clarify from the outset, there are no changes that are required of you yet, right? There's a whole process that the government is going to go through to move over what could be up to a year, although it may be a little bit shorter than that, from moving from this proposed rule to a final version. We also expect that the final version will look somewhat different from the proposed rule. In fact, for those of you who've read it, the department has repeatedly solicited comments from the community, especially on particular questions that it has that may influence how it writes or alters the text of the proposed rule to the final rule. So we will, of course, do another series of webinars and entire training courses on the final rule once it is available, and that will be the time when you move to modify policies and procedures and begin retraining. But this is a taste. This is an introduction, and hopefully this will allow all of us to inform our judgment as to what kind of comments we want to provide to OCR once the 60-day notice and comment period opens. It hasn't opened yet. It'll probably open in close to 2 weeks. And then we'll have 60 days from there. And so hopefully the discussion that TNG's partners and our ATICSA team leads you on today will allow for informed comments that will speak to your particular school, your community, your environment, your college, your university, and the needs that it has. So we have titled this an NPRM Notice of Proposed Rulemaking Primer. You can see that there on the slides. I don't know who amongst our team came up with that very clever idea. Is that you, Kim?
No, it was all Meg, our fearless executive director, came up with that gem.
Then kudos to Meg for the NPRimer, or however you choose to pronounce it. What you need to know about the new Title IX Notice of Proposed Rulemaking. As you can see on the next slide, we have joint sponsorship today between ATICSA, TNG, and NBIDA. My name is Brett Sokolow. I'm here in my capacity as chair of TNG and as ATICSA's president. If I could ask my co-panelists and partners to quickly please introduce yourselves. starting with Kim.
Hi, welcome. I'm Kim Picelli. I'm one of the partners at TNG, and I'm a member of the ATICSA Advisory Board.
And Joe.
Hi, my name is Joe Vincent. I am a TNG consultant, a member of the ATICSA Advisory Board, and very pleased to be here with you all today. Thanks.
Joe, is this the first time we're introducing you publicly as a partner, sir?
Well, I didn't. I don't even know when we're supposed to do things like that. But yeah.
Now's the time, Joe.
Now's the time.
One day, very, very close to this day, I get to join the hallowed ranks of partnership at TNG. I'm very excited for that and humbled. So yeah, this might be my first foray into that level of authority. So who knows? We'll see how it goes.
Congratulations and welcome, partner. Daniel.
Is this the point where we disabuse Joe that he thinks he has authority and we really have none? I'm Daniel Swinton. I'm a partner with TNG and vice president for ATICSA.
Thank you for being here. Sonny Schuster, do you have a voice at this point? Sonny looks like she would even be frozen.
Sonny is ill.
Yes, Sonny is voiceless and is having computer issues at the same time. Well, we will welcome her once she has a chance to re-sign on. I think that's our entire panel, right? Am I missing anybody?
No, you got everybody.
Good. Then let's take a look at our agenda slide. You'll see where we are headed today. We're going to talk through the scope and applicability of the proposed rule, move on to a section of definitions and a discussion of reporting in response to disclosures, the requirements that are elaborated by the proposed rule. Then we'll shift, those will be mine to present. Then we'll shift into some of the other panelists. Intake and preliminary inquiry is our fourth topic. We'll delve into investigations fifth, decision-making sixth, the various models for that that are proposed. Some key observations for K-12, although we'll expand more on that in the next upcoming webinar that Meg mentioned, is our seventh topic. And then, these rules include a tremendous amount of information about pregnancy and the rights of pregnant and parenting students and the need for lactation spaces. So we'll talk all about that in our final section on pregnancy, which is section number 8. So I'm going to start us off by talking about the scope of the proposed rule. And so let's take a look at slide 4. And you'll see that this is a broader scope than the 2020 regulations, which address what we've come to call the big 5 offenses, although different people count them differently. So there may be 6 depending on how you count it. But you'll see an expansion in the proposed rule to not just address sexual harassment, and what the proposed rule renames as sex-based harassment. So we'll use that terminology here today, but also a wider protection for discrimination on the basis of sex. And that would include behaviors rooted in sex stereotypes, sex characteristics, pregnancy or related conditions, protections related to sexual orientation and gender identity as an expansion of the protected classes that come within the ambit of this proposed rule. When we talk about sex stereotypes, that really is no different than Title IX's coverage has been for decades. And so it has always been a position of the Department of Education that when behavior is rooted in sex stereotypes, the conduct can be on the basis of sex and therefore protected by Title IX. Sex characteristics is broader, and you'll see in the proposed rule what it addresses, but primarily designed to address those individuals who are intersex and to make sure that their protections are identified within the scope and ambit of Title IX. We've had longstanding protections for pregnancy and related conditions, but this offers a clarification that we'll delve into in that 8th section of today's conversation. And of course, sure to gin up the most discussion and controversy will probably be the protections for sexual orientation and gender identity that have been incorporated. This should come as a surprise to no one, as the Department of Education signaled that it intended to expand these protections within the scope of the proposed rule, and has done so really at the direction of the Biden administration and the executive orders that pointed the way toward these protections. And so I imagine as we go forward that a lot of the comments to the proposed rule are going to focus on protections related to sexual orientation and gender identity. Most of you should be aware that the Department of Education has not proposed to change the exceptions related to religiously affiliated institutions that want to exempt themselves from certain aspects of Title IX compliance. And so that those protections of sexual orientation and gender identity will mirror some of the protections that already exist in federal law under Title VII and protections that exist under many state laws as well. And I think that we'll learn a lot from the rulemaking process with respect to topics like bathroom access, facilities access, issues of discrimination that may involve dead naming or mispronouncing or misgendering. Specifically, though, this rule does not address gender identity in athletics. The Department of Education has effectively punted on that topic for now and has said that it will address that topic in its own separate rulemaking process, or that it will look to whether it wants to address that topic in its own rulemaking process down the road at some point. There's no timeline that we're aware of. And then, of course, the scope includes sex-based harassment, as you see at the second to last bullet point on slide 4, which covers the big 5 offenses that we've come to know and if not love, at least know and know and use under the current regulations. And so the proposed rule essentially adopts a similar scheme. And so those are the key areas of scope that we'll be talking about with respect to the proposed rule today. We want to also talk about its applicability. And you see this on slide 5, where the scope is to the recipient's education program and activity. And that's language that should be familiar to all of us. We've worked within that concept before. It exists in the current regulations, but it's the way that the Department of Education is now defining it and expanding that scope, quite frankly, that will provide for a new level of compliance obligations on schools and on colleges. I think probably a lot of you have heard the buzz and seen in the media some coverage that it may well be that schools are obligated as the result of this proposed rule to address all conduct, whether it's on campus, off campus, in school, out of school. And while I don't think the rule goes as far as requiring a blanket, you must address all sex-based harassment regardless of where it occurs, they're creeping pretty close to that. And they do it through a set of provisions, one that addresses the disciplinary authority of the recipient, and then the other that addresses what we call the downstream effects, right? The in-program effects of out-of-program or off-campus misconduct. And so through both of those, I think the department is planning to cast a fairly wide net. So you see very specifically in this first sub-bullet point that the authority will now extend to what is considered within a recipient's disciplinary authority. And essentially the rule as explained in the preamble is that if there is similar conduct addressed by your district, school, or college through a different process off campus, then you would also be obligated to take off-campus jurisdiction of that similar conduct through your Title IX process. So a lot of us, I think, are going to be trying to reconcile now the question of, do we expand our off-campus policy jurisdiction statements? Do we contract them? Do we leave them as is? And what does that obligate us to? And of course, the rule also extends explicitly to buildings that are owned or controlled by student organizations that are officially recognized by a post-secondary institution. That's not applicable to K-12. And this is not dissimilar from the very same language that is in current regulations. And I think, too, as you look at the second sub-bullet, the downstream effects piece, the department seems to be portraying this as new or different in the regulations. Having discussed this internally at T&G, we're not really sure it is new, but it's being cast that way and certainly framed that way in the media. But essentially what it's saying is if there's a hostile environment created on the basis of sex in your educational program by conduct that occurred outside of the program, that you are obligated to address and remedy that conduct, the hostile environment within the program. So it's not saying you have to address the off-campus incident that created the hostile environment in the program, but that you must address the hostile environment in the program. And to the extent that current regulations already address hostile environments, though they don't call it that, they just use the term sexual harassment, and we would always be obligated to address hostile environments that arise in our programs, regardless of how they arise or from where they arise. I don't see this particular rule as enormously different than the current regulations, though I think read together with the disciplinary authority rule above, it does bode for us potentially as a community that we will be addressing a much wider range of conduct. I think for a lot of four-year and residential colleges, they already take pretty broad off-campus jurisdiction. So I don't know that this is necessarily a change in business, although I think for many K-12 schools, it really potentially could be because historically they've picked and chosen, right? They like to address off-campus harassing speech, but not off-campus sexual assaults. And I think the regs are pretty clear on that. It's going to be an all or nothing proposition with that kind of behavior. You either take jurisdiction over all off-campus sexual misconduct or none. And so that'll be an interesting decision-making point that our K-12 members and community face going forward. And of course, there's also provision on the applicability to policies or practices, you see this in the bottom bullet point on the slide, that prevent participation in a program or activity consistent with gender identity, and that subjects a person to more than a de minimis harm on the basis of sex. So they've proposed a fairly low threshold. De minimis is just the Latin or lawyer's term for more than minimal harm, and really refers to an interesting clash, I think, with some of the case law that is now being developed around the country on concepts like misgendering and dead naming and mispronouncing. And so we'll have as a community to really come to terms with the question of whether those behaviors subject individuals who are trans or transitioning or non-binary to more than de minimis harm. And then there would be an expectation within the regulations for the recipient to address that behavior. Not so sure whether we're legally permitted to discipline it. That's going to vary from jurisdiction to jurisdiction and has fascinating First Amendment implications that we'll be addressing down the road in future webinars. But really something to get your gears turning in your heads as we set this up for your consideration. Let's turn to slide 6. This is a section called 106.2. It already exists in federal regulations, and a lot of definitions appear in this section. As a matter of fact, more of the definitions that exist in the current regulations that the department considers to be misplaced are being moved into this definition section. And so some of the things that you'll see defined in this as you work your way through, and we've offered you page references here that I hope are helpful to you, is the idea that we addressed in the scope slide just a few minutes ago, that sex discrimination is defined as broader than just the sexual harassment big five offenses that are in current regulations. There's no explicit definition of sex discrimination, but there are descriptions of the behaviors that would fall within this. And really what they're referring to here is the classic concept of disparate treatment. Though the proposed rule doesn't use those words, they've essentially made the argument, I think it's a reasonably good one, that there's no reason to treat sex-based harassment different than disparate treatment on the basis of sex. And so whether that's pregnancy-related discrimination, LGBTQI-related discrimination, pay-related discrimination, they call all kinds of things that athletics-related that fall within disparate treatment that aren't the offenses of sexual offenses or sexual misconduct themselves. We've got definitions related to pregnancy and its related conditions on 654 and 55, definitions of that program or activity that we just talked about later on 655. We've got a definition of relevance for the first time, which is, I think, a welcome inclusion. We're supposed to base our determinations on the basis of relevant evidence. And if you read current regulations, they said, well, it's up to you to define relevance based on its common sense meaning. I guess this Department of Education, OCR, said, we don't believe that relevance is all that common sense, so we're going to define it for you. And they've given it an enormously wide definition. Anything that really aids in determining whether sex discrimination has taken place is going to be considered relevant under these new rules, although there are some specific exclusions of impermissible evidence that we'll delve into in later dates. They've talked a lot about supportive measures. Supportive measures is a section that has changed dramatically from the current regulations, so we'll talk you through that in just a little bit, and a change to these regs as compared to the current regulations that say we can define consent on our own These regulations just say it's kind of inherent that it's in there. We know you need to do that, but we're not going to say you need to do it because it wouldn't be logical to put a non-definition in a section on definitions. So there is a requirement to have a definition of consent, but it's not in the definition section of this proposed rule. As we flip over to slide 7, you'll see some additional definitions. Go back one slide for me. There you go. To sex-based harassment itself, which again used to be called sexual harassment and has now been renamed. I think the renaming is largely to reflect the inclusion of gender identity and gender-based harassment within the scope of Title IX. And so OCR felt that the term sexual was limiting and wanted to broaden out the terminology to reflect the broadened scope. There is a continued definition of quid pro quo harassment. That's harassment between employees and others that is conditioned on aid, benefits, or services of the recipient. And the definition of quid pro quo is for the most part unchanged. It's a little bit clearer that the conditions can be implicit or explicit, but otherwise the quid pro quo definition largely tracks the definition in current regulations. And then, of course, one of the things that perhaps those of us at ATIXA are most excited about is the opportunity to finally get rid of the dreaded acronym SPOO, right? We have been saddled with this thing since 2020, and SPOO is our sort of acronym for severe, pervasive, and objectively offensive, the definitional elements of hostile environment harassment as they currently exist. The department has proposed to move toward the Title VII standard, also the Fair Housing Act standard of using severe or pervasive, which I guess we'll call SORP instead of SPOO. And so this will bring within the scope of Title IX, I think, a broader range of behaviors, of conduct, of verbal conduct. We still have to be careful as institutions, especially those of us who are subject to the First Amendment. If we're public, we still have to be careful of over-application of this standard. And those of us at TNG think this is really going to wind up in quite a bit of litigation. The department has taken the perspective that the SORP standard, severe or pervasive, is one that is consistent with the First Amendment and protections of freedom of speech. Ultimately, it's going to be up to the courts to be the arbiter of that particular question. And I think that those lawsuits will occur sooner than later. We also have definitions of sexual assault, dating violence, and domestic violence. This is very similar to the current regulations, though the department is moving toward actually incorporating definitions rather than referencing other federal statutes or regulations where those definitions can be found. We have a definition of stalking that is completely consistent with current definitions. For those of you who are interested in the question of whether you have to update your domestic violence definition for the changes to the Violence Against Women Act that are coming October 1, the department has included a section that explicitly rejects the inclusion of technological abuse and elder abuse and the sorts of things that VAWA adds to its definition under Title IX. So that is an interesting point to pay attention to. Also, the definitions of the offenses of sodomy and sexual assault with an object, which were 2 of the 6 sub-definitions of the sexual assault offense, those have been removed consistent with the new SRS program of federal classification of sex offenses. So there are really now only 4 sub-offenses to the sexual assault definition, not 6. I really like the next slide, and I thank my colleagues, if we look at slide 8, for giving us a graphical representation of something the Department of Education has decided to convolute and make pretty complicated. ATIX's recommendation, I can assure you going forward, is going to be, if you already have everybody as a mandated reporter, just keep it that way. Don't mess with success. It's a workable program. And again, the federal standards in this, I think across the board in this proposed rule, really give us a nice floor. And unlike the current regulations, give us an opportunity to exceed that floor pretty much anytime we want, and to really aim for the ceiling of best practices. And you're going to hear a lot of that tone from ATIXA over the next 12 months in terms of, yes, here's what the regulations lay out at a minimum, but there's really so much more we could do on this to be truly excellent. And so while we don't have an official position on that under the new rule, we'll make sure that there is one once the regs are finalized. As they're proposed now, who you are within your institution really defines your obligations to report or not report information to the Title IX coordinator, but it also matters who you're receiving information about. And so this little chart that we've put together on slide 8 tries to elucidate that that set of distinctions. And so if we could stay on that, I just want to walk it through really quickly. We've got confidential employees, and we can classify people as confidential, or they can be confidential as the result of having a privileged role, such as being a mental health professional. When a disclosure is made from a student or an employee to a confidential employee, there's no obligation to notify the Title IX coordinator as long as that employee is working within the scope of their licensure or confidentiality. They do provide information to about the Title IX program to those individuals, but they don't have to notify the Title IX coordinator directly. Then there's the employees with authority to institute corrective measures. The OWA construct doesn't really appear in this proposed rule, right? The officials with authority became a term of art under the current regulations. Now they just describe employees with the authority to institute corrective measures on behalf of the recipient. When they receive disclosures from students or employees, there's an obligation to notify the coordinator and to provide information about contacting the coordinator and the Title IX process. That's probably the broadest requirement. And then there is another category of employees who have responsibility because they have administrative leadership roles, teaching roles, and advising roles. And here advising is defined as not just academic advising, but advising student organizations. It's a broad definition where if disclosures are made from students or about students, there's an obligation to notify the coordinator and to provide information about the Title IX process. So the obligations here are commensurate with those of an OWA. Under the current construct, or someone with authority to institute corrective measures. And then for employees, you get to choose one or the other. You can either notify that employee of their rights under the Title IX process and how to contact the coordinator, or you can notify the coordinator directly. You'll see the same choice for all other employees who are not confidential employees. Whether they receive information about a student or an employee, they can choose one or the other notification requirements. This is specifically applicable to higher ed. This is not the K-12 construct, which we will talk about just a little bit later. But here, the choice is up to the person who's reported to in terms of whether they notify the coordinator directly or just inform the individual about how they notify the coordinator. If the person who's reporting the conduct is reporting it on behalf of someone else, they're a third party, it would be sufficient to notify that third party of the rights of the person impacted to notify the Title IX coordinator and to know what the Title IX process is and how it works. As we work through slide 9, just a little bit more on reporting requirements and response disclosures. There's an explicit description that employee self-reporting is not required. This has been a long-standing rule within all discrimination case law. It's good to see it extended here and made explicit. So if you're an employee, you've experienced sexual harassment or sex-based harassment yourself, and you're obligated to report, the obligation to report would not extend to your own experience. Only those of third parties reported to you. You see a little bit more information on confidential employees here on slide 9. Those individuals should be listed somewhere. You've got to notify the members of our community of who we consider to be confidential, who we're designating to be confidential, or who is confidential by virtue of their role. And they must explain their confidential status when a conversation about a Title IX issue arises, and again, provide that Title IX coordinator and process contact information. There's also an explicit carve out for public awareness events that occur in post-secondary environments. The institution is not obligated to respond formally to information, call it notice, or the department doesn't, but to notice of sex discrimination or sex-based harassment provided during public events like Take Back the Nights or online activities that are designed for awareness raising, prevention, and the like. There will be an institutional obligation to address whatever is learned by employees in terms of remedies, in terms of the greater safety of the campus community, but no obligation to respond formally to information that is conveyed at those events. There are also, of course, revised training requirements, which we'll all learn more about eventually. They're broad, probably a little broader in some ways than existing training requirements in the current regulations, because of the need to train all members of the community on their reporting requirements. And there are some slightly expanded administrative requirements that are part of this reporting process as well that we'll drill down on in future conversations. So that really is, I think, the core of some of the key issues of scope, applicability, of definitions, and of reporting requirements. Let me turn at this point to my colleagues, and I see everybody live tweeting or live chatting. I haven't had a chance to look at that or weigh in, but I'll take some time to do so now and see if I can contribute. But please, Kim.
Great. So I'm going to take it away. We're going to we've organized this as if a report comes into the institution and school and sort of moving through the process. So I'm going to kind of focus on issues associated with the Title IX coordinators intake, and really we've resurrected little I inquiry as a team, right? That idea of sort of all of the initial things, bundle of things that a Title IX coordinator is doing when a report comes in, when the institution or the school receives notice of the form of sex-based harassment. And so, or discrimination, I should say, because obviously, we've got that very, very clear kind of broader lens. One question I want to tackle that's in the Q&A that I think would be useful, because we've got the answer to it kind of peppered throughout the slides, but it's not a slide that speaks to it specifically. As many folks will remember and know, well, you've been trying to figure out how to do this for the past couple of years. There is a lot more flexibility about roles and division of roles, and even sort of the lack of a requirement of division of roles. And so the question came in, I think, and I can't see it, but may the Title IX coordinator also be the investigator? And the answer is yes. May the Title IX coordinator also be the decision maker? Yes. And even you could imagine a system here where the Title IX coordinator is one human and the investigator and decision maker role are done by a different but same human doing those two jobs. So there's a lot more flexibility, and ATICSA is already giving thought to what we're going to be advising and recommending. I really think what OCR was after here was a lot of flexibility, right? We all represent many, many different kinds of settings with different staffing structures and different constraints. And so there's a lot of flexibility in that particular space. So I'm going to talk about this work that the Title IX coordinator is doing at this moment. Of course, it could also be a deputy, and the regulations speak very clearly to the role, to the dimension of delegating some of these responsibilities. So what happens after notification, right? What happens after the institution or the school has notice of the allegations? And the requirements are very clear that the Title IX coordinator needs to treat the parties equitably, needs to either sit down with the complainant or reach out to the complainant if we're in receipt of a third-party report. Maybe someone hasn't made a self-report. Make sure that the complainant is well informed about the procedures and how to file a complaint or seek a complaint, make a complaint. And I'll say more about that in a minute. The same kind of construct that we have now, I've got to offer supportive measures and make sure that I'm providing those and make them potentially available to both complainant and respondent. And then there's this idea of a complaint, right? So we have that construct that's still existing from the 2020 regulations. That is when our complainant says, Title IX coordinator, I'd like to initiate the grievance procedure. I'd like to move forward with the investigation. I'd like to move forward with the process. And the big change that we have is that request, that complaint, can be either verbal or written. So the formality of the formal written complaint that we've grown accustomed to in the 2020 regulations has been made more flexible. The Title IX coordinator still has that obligation to potentially initiate the grievance procedures when in our judgment circumstances are appropriate. Remember what we teach, the pattern, predation, violence, threats, weapons, minors, those kinds of factors. And just generally, the Title IX coordinator needs to take prompt and effective steps to stop, prevent, and remedy, even if a complainant does not want to move forward. But the construct remains the same. Complainants really do retain a lot of authority about whether to move forward with the grievance procedures. Moving forward on the supportive measures front, on the next slide, we had a rich internal discussion about the formulation of this provision, and a lot of it will seem familiar, but there's a sort of an important shift that OCR is proposing to make, which is supportive measures are intended to restore and preserve access. We need to be as even-handed about it as we can. We need to reduce as much burden as possible on a respondent. However, in very certain circumstances, we could conceivably put supportive measures in place that have some degree of burden on our respondent, but we can't be doing it for punitive or disciplinary reasons. We need to do it in order to restore access or preserve access for the complainant, and only during the pendency of the grievance procedure. And the key thing is, and as a field, folks are going to need to be very judicious about how this is applied. We've already been sort of thinking and talking about sort of how we'll convey it, is we need to provide a process by which the respondent can challenge when we do this as well. So supportive measures stay intact in many ways, shape, and form, but frankly, we have a little bit more flexibility in terms of how we apply them. Moving toward the emergency removal and the administrative leave provision, it remains largely intact. Emergency removal provision applying to removing student respondents, administrative leave to employees. There's some distinction here, but that same individualized risk and safety analysis applies. And so the systems and structures you've already developed will be put to good use. Dismissal, everyone's favorite topic from the 2020 regulations. OCR has heard us. And in the proposal, the entire concept of dismissal is moved to a permissive model, whereby the Title IX coordinator has the flexibility to potentially dismiss a grievance procedure when it comes in. And there are these 4 factors, sort of 4 reasons, one or more of them may be present. Then there are various requirements depending on the setting, whether we're in a K through 12 setting or whether we're in a higher education setting, about what kind of notification is provided to the parties of a dismissal when it comes up, and as well as what an appeal process might look like. But that idea of a potential dismissal of something, and that the sort of the 4th factor here is the one that we've been familiar with, right? Is that when we have allegations that come forward that would not constitute sex discrimination under Title IX, even under the scope that's now what we'll be working with, that we can conceivably dismiss it and potentially handle it under another process if necessary. And then last but not least, informal resolution is maintained. One significant change is that a Title IX coordinator can explore with the parties whether to pursue informal resolution from the earliest point. You don't even need that complaint to say, yes, please start the grievance procedures. If circumstances seem appropriate, if the parties agree to it, if the Title IX coordinator agrees, you do need to provide some clear notice about the procedure so that everybody understands the realm in which they're exploring. And there are some other procedural requirements around what an informal resolution looks like. It's not required that institutions do it. It's an option that you can offer under your policy. And really the key thing is that a person who could ultimately investigate or serve as a decision maker cannot be the person who facilitates the informal resolution. So there is still a little bit of that staffing shuffling around that's going to happen as well. Joe, I think we're about to transition over into the official grievance procedures and the investigations.
Yeah, I think we are. And in a lot of ways, the attention that the prior round of regulatory action sort of drew to the process for resolution in terms of whether or not there needs to be a live hearing, what cross-examination looks like, and how that's facilitated. Daniel really gets maybe some of the most high-flying highlighted portions of the proposed regs as it relates to those changes.
Thanks, guys.
I
Appreciate that,
expect,
everyone. Yeah.
I expect that all of your eyes, even if you just had a chance to skim the regs, were drawn to what have they done with these particular provisions. And so this is a framing conversation, because as we look at the way it impacts investigations, it's difficult to talk about the framework that the proposed regulations describe without talking about it in the context of the decision-making process. And so what you should know at the outset, and as I said, Daniel's going to unpack this more, is that the regulations envision two approaches to resolution. They describe one approach under 106.45. That section may sound familiar to you. So this would be a new 106.45 that sort of replaces the old. And creates a lot of flexibility for schools and institutions to approach resolution with less procedural specificity and more discretion to choose a method for resolution that fits your environment best. And I think many of you, particularly our K-12 colleagues that are on the call today, are going to be pleased to see the level of discretion that's granted to you for resolution under 106.45 as it relates to K-12 environments. But even in higher education, you probably noticed in the definition section, there was a distinction drawn between sex discrimination and sex-based harassment, right? And the retooling of those definitions has also created a bit of a bifurcated approach as it relates to the way the regulations describe institutions approaching resolution, so that you might think of it in a similar framework to how we have described process A and process B, although those distinctions are different under this framework, but in the sense that there's less procedural specificity for sex discrimination in higher education and the number of sort of procedural requirements that attend those types of resolutions. And then what we see in 106.46 is a more specific, it's probably going to look more familiar to you, approach to resolution as it relates to sex-based harassment involving a student as a party, one or the other, in higher education specifically. We'll let Daniel unpack that, but how that impacts investigations is significant. Now, what we have in the description of investigations under the proposed regs is likely a lot of stuff that you're accustomed to seeing, right? The same sort of mandates for equitability in terms of the conduct of the investigation and the promptness of initiating the investigation remain. There are some interesting, and I think I appreciated, explicit statements about taking steps to ensure the privacy of the parties and witnesses that are involved in the process during the investigation and decision-making phase. Certainly, we still have the statement that the respondent is presumed not responsible. We still have the sort of focus on eliminating the influence of bias and prejudice and conflicts of interest in the process as it relates to the administrators that fill the roles, including the investigator role. The same sort of framework for a notice of investigation and allegations. Under 106.46, this picks up a little more specificity with what's required to be included in the NOIA, but even in 106.45, the less procedurally rigorous section of resolution procedures, we get this idea that a notice has to include a description of the grievance procedures, if there are informal resolution options available, description of those and how to engage them. Certainly this idea that you have enough information about what's been alleged that you can sufficiently and adequately respond. And then the sort of familiar statements that we're accustomed to seeing, like those prohibiting retaliation. Moving on, there's still the same sort of mandate. I think maybe a new mix of terms as the department finds a way to describe that mandate. So the terms that they adopted in this round of regulations are adequate, reliable, and impartial. So those of you who have been through investigator training with us, those terms likely sound familiar, and they still sort of encapsulate the same concepts for conducting an impartial investigation appropriately. Burden of proof idea and the equal opportunity to present evidence are concepts that remain or hold over from the last round of regulations, and probably even beyond that. And where we get interesting distinctions, by the way, I've moved to the next slide. I'm sorry, I probably should have made that more explicit. Where we get distinctions that really begin to bear on our work when we get to this idea of relevant evidence, right? It's not a concept that's new to us. We've been talking about relevant evidence and the sort of departmental focus on relevant evidence for the last couple of years, but we've done it in the framework of separating evidence into these sort of partitioned. We've used buckets a lot, and I can tell you behind the curtain, all of us are very excited to dispense with the notion of buckets as it relates to the separations of evidence. And the department has simplified that so that they say what I think we all always suspected, that if evidence is relevant in that it relates to or pertains to helping the decision maker determine whether or not the allegations are supported, then it's relevant. And it should be presented to the parties for inspection and review. It should be provided to the decision maker to facilitate decision making, regardless of who that person is. And I think we've already discussed the investigator can be the decision maker. So that's an interesting new role that we may see either coordinators taking on, who are now investigators and decision makers, or investigators adopting and developing some new skills for making findings and writing outcomes. It's going to create some really interesting professional development opportunities, I think, in a lot of areas in the field where we'll have the ability to take on some new skills or some new steps in the process. And we still have this provision that we are required to provide and create an opportunity for the parties to review relevant evidence and respond to it. This isn't the same as the 10-day rule, right? And so if you're hearing that very distant cheer of joy, what you're hearing is all of our K-12 colleagues recognizing that based on what we've discussed so far, an investigation process involves a collection of relevant evidence and the provision of that relevant evidence. You'll note there's no mention of a report in here, which I think is it's going to be an organizing document that we're still going to recommend you create. But in terms of the procedural rigor and the specificity for how these steps are intended to move through the resolution process, there's a lot more flexibility, particularly for our colleagues in K-12. But as it relates to all sex discrimination, to approach the resolution process as what works best for us in our environment, in our administrative culture, what's efficient but still provides folks the rights that they're owed, but allows us to move to resolution likely faster than the older framework and regime for resolution did. And so in K-12, we can envision a process. And again, I don't want to steal any, Daniel gets all the good stuff, but once we get to resolution, stuff. Well, what you'll start seeing is, I'm just happy thinking about K-12 administrators with smiles on their faces, is we get to migrate sort of back to the type of addressing an incident, investigating the incident, reviewing that evidence, and making a decision in a manner that likely we're more accustomed to in those environments. And where we saw the old regulations framework take some of that autonomy and discretion away, these proposed regulations envision injecting some of that discretion back in and granting some of that expertise and authority back to the schools themselves to figure out a system that works best for them. Now, what we see in 106.46 is the description for the approach to sex-based harassment, which you may have caught Brett described in the definitions portion there as describing a subset of behaviors that fall within the larger umbrella of sex discrimination, but align more closely with what the 2020 regulations described as sexual harassment, with some obvious exceptions, but we're working kind of in that ballpark. Whenever we're in higher ed and whenever we're dealing with a student as a party, a respondent, a complainant, or when students are both or all parties, then we're required under those specific circumstances to use a few more of the procedurally prescriptive elements of 106.46. And so the way the regulations are crafted is such that they say, look at 0.45, do everything it says in there, as well as these things that we're going to outline in 0.46. And so, as I said, you get some more specificity as it relates to the notice of allegations and investigation. So some more required disclosures. Those likely don't look unfamiliar to you. Most of your NOIA templates accomplish these disclosures now. On the next slide, once again, it's likely still looking fairly familiar in terms of a written notice is required for all meetings and interviews or hearings with sufficient time to prepare. There's a provision under 0.46 that explicitly mentions the allowability of introducing expert witnesses. Sorry, I've gone to the next slide again. Expert witnesses are explicitly permitted under 0.46 where they're not mentioned in 0.45. And so we had a little bit of internal discussion about if that's intentional or what that may mean, but certainly in 0.46 and these higher ed student involved sex-based harassment cases, there's a provision that makes that explicitly allowable. The same sort of ideas for reasonable extensions and written notice to the parties if the process is delayed for a reasonable excuse. And then again, this idea that the equitable access to the relevant evidence and everything that doesn't fall under the umbrella of impermissible. And when we say impermissible, right, we're talking about those things covered by confidentiality or privilege, things that would fall under the customary rape shield type protections that you've heard us talk a lot about in training. That we give them an opportunity to review and respond to that evidence. But once again, this isn't a clearly delineated 10-day period as you're accustomed to doing now. Matter of fact, the regulations make the statement that response to a single round of review of the evidence could happen at the hearing itself. So that those periods for review and response are sort of compressed, they're combined, and it makes for a far more efficient process for sharing and reviewing and responding to the evidence in anticipation of some sort of decision-making process. On the whole, I think what we see from an investigations perspective is that some of the rigor in places where it's helpful to have it diminished and discretion re-injected, the department, I think, has acknowledged that and has given us some more of that discretion. I expect that some of our best practice advice will remain the same as it relates to the way we conduct these investigations. But we may see investigators adopting new roles. We may see investigations themselves moving more efficiently through to the next stage of the process. And that carries us to the place where Daniel's then going to break down what decision-making looks like and sort of the menu of options that institutions and schools are offered for adopting the best resolution process that fits the issues that they're dealing with.
All right, so decision-making, as folks said, they assigned me this one, which meant I stayed up all night. So thanks everyone. That was really sweet of you. And we're supposed to be hazing Joe. He's the new one. No hazing is permitted. That's a very bad thing. So no, in terms of decision-making, this is where we see this bifurcation. You've seen it in the chat a little bit. Joe talked about it. The split between 106.45, which right now is all of the procedures for decision-making and investigation. What the proposed regulations do is they say, okay, we're going to make 106.45 the issue involving really K-12. So elementary and secondary schools is what they say, employee on employee misconduct, and certain types of sex discrimination in higher education. 0.46 is where we're going to have the enhanced due process requirements when something meets the definition of sex-based harassment. Okay, so when I'm focused on 0.45, the elements in 0.45 actually almost all transfer over to 0.46 as well. Not all of them, but many of them do. And so when I cover some of this, some of that's going to transfer over. The key thing that they say is in any kind of case, you have to have this decision maker who can assess credibility. Okay. And then they offer us a couple of options for how to do that. In 0.45, they actually say that you can do this in a way that's more consistent with the single investigator model, which they actually cite to single investigator model in the preamble and say that that is now permissible under 0.45. Okay. The other thing that they do with this is this, and they said that's enough to test credibility as long as you allow for some questioning by the parties through really the decision maker. That's the best way to sort of handle that. Okay, is to funnel that, shuttle that back and forth a little bit. From an evidentiary standard perspective, they've shifted from the term evidentiary standard or standard of evidence to standard of proof. Okay, and so when we see in here on the second bullet point, it says you can use preponderance of the evidence unless used clear and convincing for all comparable proceedings. Now, my mind was blown about 4 hours ago, when I read in the preamble, page 355 through 357. I called Kim, we got Brett on the phone, and I said, oh my word, comparable for OCR in these proposed regs means between the same type of individual as well. So if you are using preponderance of the evidence for all harassment discrimination cases between students, you can use it for Title IX cases. If you're using clear and convincing for all discrimination cases involving employees, you can use clear and convincing. What that would mean is you could have preponderance for student on student cases and clear and convincing for, or preponderance for any case where student is respondent and clear and convincing for any case where employee is respondent or vice versa. Okay, so when it says all comparable proceedings, what that's referring to is this sort of track as employee as respondent, student as respondent. It says a student as respondent case is comparable to other student as respondent cases. An employee as respondent case is not comparable to student as respondent cases. Okay, so that's a very, very key thing that none of us picked up on in the regs, but was actually in the preamble itself. There is an indication in 0.45 that we notify the parties of the outcome of the complaint. Now, one of the things I would like to see from OCR moving forward is a better definition of what outcome includes. To me, that would be finding, sanction, and rationale, but it's not clear to me what that is. The other thing with that is if you're under 0.45, that doesn't even need to be in writing. That can be verbally articulated to the complainant and or the respondent. So that doesn't have to be in writing. Now, best practice, put it in writing, right? Again, we're setting the floor instead of the ceiling. They also say that an appeal under 0.45 is not required. But if you do offer an appeal, that needs to be offered to both parties, okay, to complainant, respondent, using the grounds that they specify in the regulations. And they didn't really change those grounds. Those grounds are mostly the same. And then they just reiterate that the Title IX coordinator is the one who works on and provides remedies and sort of, they talk a bit about sort of doing spot checks of these, making sure that these things are still necessary as you go forward. Let's go to the next slide. All right. So now we get to 0.46. So if you're wondering, is that it for 0.45? It kind of is, right? They're basically like, you need to provide them notice, like what Joe was talking about, an opportunity to be heard, which can be in front of the investigator / decision maker in their statements. And then you provide them notice of the outcome. That's about it, right? I mean, there's not a lot more. In the preamble, it goes into a little bit more detail, which certainly we'll be providing you all over time as we digest it. But then we shift to this 0.46, which again, based on that chart that Joe showed us, is for student on student sex-based harassment. Okay, what primarily falls under that is quid pro quo, hostile environment, or SPOR now, right? Domestic violence, dating violence, and stalking. So those are the primary things that fall under sex-based harassment. If you read the regs, there's actually some confusion, at least for me, as to what forms of discrimination. That's in 106.10. There are references to that make it sound like it may be including elements of discrimination as well. We're going to ask for clarification. So in 0.46, you don't have to have a live hearing, but you do have to have at least the opportunity to have the decision maker meet one-on-one or one-on-two, right, with their advisor, with the complainant and or with the respondent. You don't have to meet with them together, to then ask them their own questions and or ask questions posed by the other party. Okay, so there's this, it's almost a shuttling. If you're familiar with shuttling, it's I've got questions here, I'm going to be the one taking them over to this other party and asking them here. There are some guidelines as to what's relevant and impermissible, et cetera. We're not going to dig into those today. But that is how that can happen. Or you can have a live hearing. And that live hearing looks a lot like what we're accustomed to under current 106.45. Go back to the previous slide just real quick. The bottom part here is critical because it says we still have this, I'll call it a bizarre evidentiary exclusion rule, right? I don't know how else to say that. This one, that I thought this was going to be gone no matter what because of a case up in Massachusetts called Cardona. But what they say with this is if a party does not answer questions related to their credibility, then I, as the decision maker, can't consider any statement that they've provided. So that's either in the live hearing or in speaking with me, okay, as the decision maker. The problem is, I don't know, I'll look to the panel as well. I can't think of many questions or issues that don't speak to credibility that I'm going to be asking the parties, right? I mean, almost everything goes to credibility in many of these cases. And so there's, again, what they're saying is if you don't answer those questions regarding credibility, we're going to throw out all the evidence you've provided. I really hope this provision, as it was a little different in the current regs, I hope that was going away because it doesn't make a lot of sense. If someone chooses not to participate, that's, they have to deal with not participating. There's just not going to be much evidence there. Even criminal defendants don't have to testify on their own behalf in a court or answer all questions. But we're kind of requiring that here. And we've seen that actually deflate complaints coming forward. Let's go to the next one. Okay, live hearing would be questioning by an advisor. Same thing, you still have to offer an advisor. If someone shows up to the hearing, they don't have an advisor, institution has to provide one free of charge, doesn't have to be an attorney, who then asks questions of the other party and witnesses. Okay, so the party themselves doesn't direct questions, but it says you can ask them of parties and of witnesses. So I've seen some schools with the current regulations exclude advisors from asking their own party any questions. My read of these regulations, and I haven't discussed it with my colleagues, is that the advisor should be able to ask questions of their own party as well as the other party. It seems to me to say the parties and witnesses, not just the other party. And again, you can have people, this is helpful where they say you can have people in one space or you can have them, technologically participating as long as you can see and hear them while that person is speaking. Okay, let's go with the next one. And I know this is prompting a ton of questions. Look, a lot of this may change. We're not going to, I'm going through some of the issues and just pointing out where we're going to be providing comments. I hope that's okay. I'm not trying to complicate this. I think it's complicated enough without me getting in the way. So I apologize if I'm doing that. So written determination is required under 0.46. So again, when you have sex-based harassment for student-on-student behavior, a written determination is required. And you can see the information that's required there. It's less than what is currently required. Okay, it talks about decision makers' evaluation as opposed to a detailed rationale. Okay, what they're trying to do, I think, here is kind of simplify what we've been doing to try and shrink the length of time. Here's the greatest thing that's gone is the 10-day plus 10-day waiting period. Okay, so, and again, these aren't in effect right now. You follow what's in place right now, right? The 10-day still lives. Under the proposed regulations, the 10 plus 10 doesn't exist either under 0.45 or 0.46, but it does say you have to give the parties the opportunity to review the information, and Joe spoke about this a little bit, to review the relevant evidence or a summary thereof prior to any sort of decision being made. Okay, you then you can determine sanctions and remedies. Appeal procedures are required under 0.46, same basic premise as what is currently required with the same 3 grounds that they currently have in the regulations. And then they basically say, look, it's either final when the timeliness for appeal lapses. So if you give someone 7 days to appeal, 7 days comes and goes, the decision is final, or at the conclusion of the appeals process. Okay, and again, all of this is proposed regulations, right? Let's see, do I have another one? Do I have another slide? No, okay, so let me go back one, because this is so much information. Let me just turn to the panel and say, is there anything else that I missed or neglected that you think is critical to understand at this point, at this overview? Kim, did you have something?
No, I don't think so, other than just to reflect like what I'm seeing and hearing, which is like that it's a lot to absorb. We know we've all been reading this nonstop ever since it came out on Thursday, trying to wrap our heads around it. And so, you know, what we're anticipating from ATICSA is pulling together either a sort of mega workshop, or it might be a workshop for higher ed, K through 12. We're sort of sorting out the best way to organize this, so that if you want to join a much deeper dive, you know, because all of these questions, I get it, they beget many more questions about what exactly are we being asked to do, and then what are going to be the right choices for my particular institution or school. So we're very much kind of pulling that together, and stay tuned. You don't need to have it all figured out today, I guess is what I mean to say.
Because we don't. We spent 4 hours yesterday on the phone and another probably hour today, and then prep for this. I mean, this is going to be ongoing, and we'll be digging into this a lot. We know most of you do not have time to spend doing that. That's one of the reasons we are here.
Yep.
We want to help you, and know that this isn't set in stone. My read of the preamble is that OCR is open to adjusting some of these areas. They use language like we tentatively propose, or this is our tentative statement or position. And so I think that there are some things here that I think will change. But I do think there is recognition that for these more serious issues, recognizing that courts have increasingly moved towards a more adversarial hearing-based model, that for these more serious issues, we need to, on student behavior, have these procedures in place. Okay. Or actually, it's anytime, I'm sorry, I have misspoken. Anytime a student is involved, if a student is a complainant or a student is a respondent, you have to use 0.46. I apologize. I misspoke. That is a critical thing, and I apologize for doing that. Again, my head is spinning. Then let me go to the K-12 stuff. Sonny was going to do this, but Sonny's voice is completely gone, and so we miss you, Sonny. And so let me just dig into this a little bit. We're going to have a separate webinar just for K through 12 on July 6th. Okay, that's been posted a few times. I think for K-12 folks, there's a bit of a sigh of relief that comes with these proposed regulations. Okay, I just did a training last week for a bunch of school districts, actually in my home county here, and trying to walk them through all the requirements. You could just watch their eyes almost fall out of their heads. So now we have something that I think moving forward, I hope they keep a lot of this. You can have confidential employees. Okay, before OCR said all employees, it doesn't matter if they're confidential or not, have to report. We can have confidential employees like a licensed counselor or something like that, which is critical. The written notification element is less onerous. You can just notify people in verbally or in writing, but give them a chance to be able to know what that is. You don't have to write an investigation report at its conclusion, and you can just notify the parties as is. Because again, you're applying 106.45. There is no requirement, I'll repeat, that you apply 106.46 to K through 12. You also have the ability to do that single investigator model. So if that VP or AP is the one who normally is investigating cases and making decisions in your student disciplinary realm, you can use that same kind of model for Title IX related cases with a few additional variables to that. You also have to be sure that you permit parental or guardian-based involvement. Okay, the regulations are very explicit about that. And then there is recognition, and I think this could be a little more clear in the regulations. There is recognition of 504 and IEP related issues. We'd like to see a little more clarity as to manifestation determination reviews, but I honestly think that you're going to be able to see resolution of these cases moving forward in K through 12 well within a week, if not less, which is a massive shift for us. And really what OCR says is that's really necessary given the environment, the age, and the nature of the situation. So a lot of the procedures they're putting in place and things that they want to put in place are trying to recognize the different environments within which we operate, that of K through 12, that involving employees, and that involving students in higher ed. All right. Turn that to the next one. Joe, I think you're covering this one for Sonny as well, right?
It's always a disappointment for anyone who has to attend whenever Sonny was scheduled to appear, and then they get one of us schlubs instead. So on behalf of Daniel, I apologize for both of us that you don't get to benefit from Sonny's expertise in this moment. However, the regulations do speak specifically to pregnancy as a condition or a characteristic that we've always known invokes the rights and protections under Title IX, right? We've seen guidance that explores and unpacks that. We've trained on that for years. What's remarkable about this formulation of regulations, I think, is that it creates a proactive burden on the recipient to make contact with and inform individuals whenever pregnancy and its related conditions are present within, with a student or employee at the institution, so that it creates an obligation that when we become aware or otherwise acquire knowledge of a student's pregnancy or related condition, that we have to inform that person that there's Title IX support available, and that the coordinator has sort of a proactive obligation to make sure that that student or other individual is aware that the institution prohibits sex discrimination, that there are reasonable modifications available that the person can avail themselves of if they choose, that they can make separate and comparable programs available on a voluntary basis to that student if they so choose such a thing, to offer voluntary leaves of absence, to inform them of a lactation space, right? For those of you who may have enough familiarity or sort of proximity to the FLSA's idea of a lactation space, we get a similar sort of construction in the regs as it relates to student availability for these same types of lactation spaces, with the same sort of circumstances and caveats surrounding those. That we have to make them aware of the grievance procedures for complaints of sex discrimination if they experience such a thing. And then, the last sort of high level observations that the regs make on the next slide, there's just a couple of extra points that we should continue to, as we have always done, extend things like programmatic access, the ability to take a leave from the program, the ability to return to the program, the sort of requirements that relate to certification, that we should extend comparable treatment to individuals with pregnancy-related conditions in the same way that we would for others with comparable temporary disabilities or conditions. Further on down, and I'm super thankful, even in reading in preparation for this, for these little references down in the bottom corner of the slides, if you want to see where we're drawing from, there is, the regs devote a little bit of discussion to the separate but similar topic of pregnancy as it relates to employees, and the types of provisions that are fairly parallel in these regulations in terms of rights and obligations that attach to pregnant employees. And so I think that once again, we're pleased to see some of this codified. You aren't going to see a lot of surprising new things in the regulations related to pregnancy, but it's nice to have them sort of aggregated and put into this one place where they can be easily referenced and inspected, and the obligations on the institution can be understood. And I think probably, and you guys can let me know if I'm wrong, because my study period for pregnancy was likely a little shorter since Sani's voice went away. But it strikes me that one of the more interesting innovations in the regulations is that there's this sort of proactive obligation to, whenever we become aware that a person is pregnant, that we proactively extend notification of their rights and the options that they can avail themselves of in the education environment as it relates to that condition. And there goes the slides. That's always a dramatic.
We did get to the question slide, so that is the end of the slides. We've moved on to the Q&A portion, which is exciting. We do have some Q&As in the Q&A function of this, as well as the option for raised hands. If anyone is interested in speaking their question, please do so. On the bottom of your screen, you will see the raise hand feature, and we will call on you. All right, Tiara Mason, if you want to go ahead and unmute yourself.
Can you hear me?
Yep.
Excellent. So yeah, just in that last kind of portion that Joe was just going over about pregnancy, I am curious when an institution becomes aware of someone being pregnant and needing to notify that person of what available resources are and what the protections are. Like, I say it with a little bit of sarcasm, but what does become aware mean in that situation? Like, how do we kind of define or document that we've met our burden there?
Yeah, it's an interesting formulation. They use that phrase "acquires knowledge," which I suppose it's sort of like I don't know that this is the framework, but it harkens to something like knew or reasonably should have known, in the sense that if you become aware that this is likely, it puts you at Tiara at risk of asking someone if they're pregnant and then they're not. So I don't know how you avoid that pitfall. But outside of that sort of social awkwardness, I think it encapsulates more than just creating an obligation for a pregnant student to have to tell you in order for you to then be triggered and obliged to provide those resources to them. Much in the same way, it's likely possible, at least at some phase, for us to become aware in some other way that a person is pregnant, rather than them directly saying it to us. That would then trigger the obligation. And it's not, let's be honest, it's not an overly burdensome obligation for us to then sort of, let the Title IX coordinator know. And I expect what they envisioned here is they're giving us the sort of like prod in the back to anticipate that this student may need a little bit of extra support, or may need to at least be apprised of their rights and resources that are available to them. And that's when that obligation would trigger.
All right, Ashley Reese, we have you next. Go ahead and unmute.
Hi, good afternoon. My question is, I noticed that there was a recommendation to provide a report, even if there is not one required. But hypothetically, if there was no investigation report, how would one sufficiently provide a description of the relevant evidence?
Isn't that interesting? How does one describe the relevant evidence without writing an investigation report?
Correct.
Such an interesting question.
We had the same question. Yeah.
I think we sort of envisioned it two ways. In environments with much simpler allegations, which Particularly, and I venture to say this, but I know my colleagues will jump in and correct me if I'm wrong, particularly in K-12 environments where it's conduct that does technically trigger some sort of Title IX consideration, but is also not particularly unusual in the context of the conduct that we ordinarily address. What it's not going to require is this giant comprehensive report like what we've become accustomed to writing over the last couple of years, where the evidence is fairly simple. And a review of the relevant evidence is probably pretty straightforward without even an organizing document. And particularly in a scheme where the investigator and the decision maker are the same person, you almost don't need that relevant information guiding document because the decision maker is already well informed. Now, I don't want to run too far out ahead, and I'm sure Daniel and others have opinions on this, but I suspect we'll continue to advise that you write an investigation report in some form, so that there's some sort of organizing document that explains how the relevant evidence fits into the construct of the allegations. But we can certainly envision some cases where just sharing the evidence, right? This person said this and this person said this, and here's the surveillance footage we pulled, right? Could be sufficient to allow them to respond and then facilitate moving on to decision making.
We did have just a really good question, actually, that I want to cite because it speaks to sort of two questions. These regs are likely going into effect between 6 to 12 months. I think Brett sort of mentioned that. We don't have a great idea of the timing. We do think OCR wants to move quickly on these. The other element to that is these have not yet been formally published, so the notice and comment period hasn't quite opened. We expect that to happen probably the week after July 4th, right? That just based on how timing goes, et cetera, that's probably when these will get posted.
And Daniel, I'll just amplify there that I think, especially if you look at the timeline that Meg posted in the chat that we had put out last week, I think that OCR intends to move more quickly than that if it can. I think a lot will depend on how many comments it receives in the review and comment period. But based on my interactions with them, my understanding is that they are hoping, I don't know if they'll be able to achieve it, but hoping to be able to publish a final rule within about 3 to 4 months of the close of the review and comment period. So we could be looking at fairly early in 2023 or sometime spring 2023.
It'd be nice. It would give us more time to comply coming into the new year, right?
Yeah, well, there's always a question then once the final rule drops about what the implementation date is. And, if the previous experience in 2020 is any, indicator, then we could see about a 60-day implementation period. It could technically be 30 days under existing law, but it will probably be somewhere around 60 days, could be more.
All right, I don't see a current hand raise, but there is one in the chat that I think is interesting. And thank you, Jessica, for putting that in there. It's for an academic medical center. Would all hospital employees be considered contributing to an educational program just by having students on hospital grounds? Would a situation between a nursing student and a hospital employee require a formal hearing under the Title IX process?
Those are two different questions. So, I guess what I mean is they get different answers. The answer to the first half of the question is no. We've understood, even going back to the case that sort of made this an issue, right? Doe versus Mercy Catholic Medical Center, that there's almost a subset of program employees within the hospital setting that are subject to Title IX. By virtue of the programmatic characteristics. And that decision is really helpful for defining the boundaries of what falls under Title IX within the hospital's operations. Now, the second part of the question is much different. As soon as you said a student nurse interacting with another hospital employee, then there's likely, under most circumstances, some educational program that's facilitating the engagement of that student with that employee in that environment. Now, that's not always true. They could be moonlighting, or they could have volunteered on their own. But if it falls within the purview of the education program, then yeah, the school's obligations would partially attach, at least as it relates to supporting that student, addressing the issue with the person with whom they've sent that student, right, and put them under their control. And sometimes it involves engaging with the hospital in some sort of like collaborative resolution process. So tons of nuance. But I don't think the boundaries change in terms of the way we identify programs in the hospital that are obliged to comply with Title IX. Hopefully that was a sufficient answer. It was.
I think it worked well.
Yeah, it's a complex. Those are some of the more complex jurisdictional issues we address, and so way to throw it in 4 minutes before the webinar is over. That was good.
All right, let's do one more, an anonymous in the Q&A. If a public institution's disciplinary process addresses behavior that occurs through electronics means, such as social media, would the proposed regulations apply the expectation for Title IX remedies as well? And if such behavior happens through a public forum, such as a public social media account, might that be mainly providing supportive resources or measures to the complainant, or what else might be an appropriate expected level of resolution?
There was a lot there. I'll start by unpacking the first one, and then I'll pass the baton on to someone else, because I was really busy thinking on the first one. I wasn't entirely listening thoroughly on the second one. I mean, the answer is it depends. I mean, whenever we're dealing with social media and technology cases, the first thing we're already asking, and the same thing we're going to be asking in terms of the new proposed regulations, is, did this actually happen inside the context of our education program activity? Are they using campus resources, IT resources? Is it a campus device, so on and so forth? Did it happen on campus, or sort of, as we think of on campus? But then beyond that, we may very well have circumstances where we have downstream effects inside of our education program activity, or we may have subsequent harassment that's occurring inside our program activity. So, we're still going to be grappling with these challenges of, technology facilitated sex-based harassment under these new proposed regulations as well.
Yeah, I think philosophically, sometimes we noodle on electronic means for essentially harassing people and presume it might be different when sometimes it's not, right? And what these regs envision is that we'll be at least appropriately more engaged in evaluating things like downstream effects and how conduct that occurs outside of the program might manifest or create conditions where there's a hostile environment or there's diminished ability to engage in the education program, right? What we've always called sort of those downstream effects. And so, however that out of program conduct manifests, I think it would behoove schools, and I'm assume we'll spend a lot more time unpacking and dissembling these sections of the regs. It would behoove schools to pay attention to that. And, the last thing you want to do is dismiss it out of hand in the way that some of the cases that are cited in the preamble to these regs did, and thus created case law that then compelled us to begin talking about how schools should contemplate and anticipate that out of program behavior can manifest into in-program effects, and that attaches obligations to respond for the institution.
All right, we do have a hand raised. Shannon Lynch, I'm going to go ahead and take you off to go ahead and talk.
Caller, you're on the air.
Just go ahead and unmute yourself, Shannon, if you would.
I apologize. I did that by accident.
No problem.
Thank you.
Let's go to Arenya for her. Go ahead and unmute yourself.
Right. Can I, I'm seeing some questions come in while we're waiting for Arena or Ariana with individual jurisdictional issues like California or New York? How do we anticipate that? If you want to speak to that a little bit, I know that's something you've been looking at.
Yeah, I mean, I think the regulations say, quite explicitly that they set a floor, and that if state law, like California's SB 493 or New York's enough law, go beyond the protections afforded by the floor and the regs, that as long as they don't conflict with the regulations, then the recipient has the obligation to comply with both. So they would comply with the state overlay, which is broader, and the Title IX obligations, which are narrower and set the floor. Of course, if there's a conflict between them, then the federal rule is going to control. But I think a lot of states are very carefully articulating state laws now that build on Title IX rather than conflict with it. I think we're going to see more and more states jumping into that action. Now that the regulations sort of create a default minimum process, and then they say, but adjust your process accordingly based on your state law or your federal court decisions in your jurisdiction. I think you're going to see more and more states jumping in to fill this due process void, just like Louisiana, Tennessee, and Kentucky recently have.
True.
I think Maine did as well to some extent, and begin to say, well, even though the Title IX requirements say you do this, state law says you do this, and they're going to heighten the floor more toward the ceiling, at least as far as due process protections are concerned. I think we're also going to provoke a lot more federal circuit courts of appeals to weigh in on the question of live hearings. Right now, what do we have? 5 circuits plus California on a state level who've essentially adopted some level of live hearing requirement, if not cross-examination. And so the majority rule in this country is still, if you're a public institution, at the higher ed level at least, there's no live hearing requirement. But I think over time, we'll see more and more circuit courts begin to reshape that.
All right, Tito, go ahead and unmute yourself.
I might have a quick question. On the sessions in October, is more of this going to be covered, or is it still going to, or are the sessions for October going to be kind of how you guys were looking at them to be before all this took place?
Yes.
D, all of the above.
We always try, Tito, during periods of transition to focus on the existing rule, but then also give everybody a heads up on how this could change going forward, or how it will likely change going forward. So we do a little bit of both. We try to avoid being tedious about it. We try to avoid creating a conversation of either or with everything we talk about. And luckily, there's a lot here in the proposed rule, as I'm sure you can tell, that already tracks with existing Title IX regulations. So while a lot is changing, there's a good amount that isn't. And so we'll point out the areas where disparity is. But of course, all of you know going forward that we're going to have what'll probably be at least a day long, if not different lengths of courses that are specifically about the new regulations, so that we can help you get up to speed and certified on those. We're also spending a lot of time now talking internally to ATICSA about whether we develop courses specifically around best practices. We've wanted to do that since 2020, but really have felt that those regulations merged the floor and the ceiling in many areas where we didn't have a lot of latitude for practice. I think the major tonal shift that is happening with 2023 versus 2020 is a move from highly prescriptive obligations to more discretion. And with more discretion, and I think there are pluses and minuses to that, but with more discretion, we have the ability to say to our members, ATICSA has always been about excellence. ATICSA has always been about trying to do more than the floor set by regulations. Yes, we want to teach you what that is, but we want to really teach you how to get Title IX right. And so I think going forward, we're going to be able to place more of an emphasis on shooting for that ceiling of best practices than we have been in the last few years. And I hope for most of our members, that's a welcome opportunity, but let's do it progressively, right? Gradually. We have to become competent at the floor before we can shoot for the ceiling. and we'll build those capacities internal to the field, just like we did back in 2011, and just like we did after 2020. So, for us, this is change, but the change is old hat, right? I said to Daniel, as we were texting back and forth earlier today, how many times in the course of our career are we going to have this opportunity to say, hey, I'm reading the new regs, and this strikes me as kind of odd, and what do you make of this? And we've been doing that, it seems like, forever, and it seems like we'll continue to do it forever. And I think on the whole, hopefully, as all of you are looking at these changes, that they're mostly welcome. I think that there's an interesting mashup here of some of the best of 2011 and a little bit of 2014 as well, right? That Q&A document. There's some of the better parts of 2020 incorporated into this. And then, as Daniel was talking about, there's just some new shit that OCR made up that we've never seen before, that is all about 2023, that's going to add to our portfolios. I'm concerned about how technical these rules are. I'm concerned that it took, what internal to us was 12 lawyers and more than 40 hours each of poring over this to make sure that we could understand it. I'm worried about anytime the government writes a rule that requires, what I call the Full Employment of Attorneys Act, going forward into perpetuity. But there is that. This is decently written. I haven't found a lot in it that internally conflicts. Which, if you go back to 2011, there were all kinds of conflicting things in that Dear Colleague letter. But it's also clunkily written. It's written by lawyers for lawyers. It's meaty. It's hard to pour through in terms of accessibility. So as usual, Atix's job is to break that all down for you, to create helpful flowcharts, model policies and procedures, the things that will shortcut implementation for you. And so, one of the things we've been talking about internally is how do we now present our model policies and procedures to you. You're very familiar with 1P, 2P. I think going forward, it may well go back to being 1P, 1P. And we'll need state-specific versions so that if, for example, you're in Texas, you can apply the Texas version that makes sense under your state laws and federal decisions. Same thing with those of you in the Sixth Circuit or Ohio or whatever states are covered. So Kim and I have been going back and forth a good bit on what we make that menu look like, right? What does the interface look like? And I just want to assure you all that while I don't have an answer to that question at this point, we're already diligently thinking about it and thinking about the ways that our models need to be updated for you, so that once the implementation deadline is looming, you'll be able to take an Atixa product right off the shelf and modify it to your particular school or institution needs, and not have to really start from whole cloth and reinvent the wheel yourselves. And that's always been our part of the value add that we're able to provide. It won't be any different this time. What will be different is, for those of you who are inundated by all of our R3, right, content, for the 2020 regulations, we're going to try and lighten up on that a little bit and give you some very succinct guidance in a variety of ways, but probably 25 different publications will not be the end result of this process this time around. And I know everybody on the Atixa team is breathing a huge sigh of relief when you hear me say that publicly.
I did want to just touch on one more question that was asked by Lane in the Q&A, because I think it's a critical change between the current regs and the proposed one. It says, are there any statutes or limitations to complaints filed by someone who's no longer participating in the education program or activity? So neither actually had a statute of limitations. However, the current regulations state that if a complainant files the complaint while no longer actively participating or attempting to participate in the program or activity, it doesn't fall under Title IX, and you don't have to take it under that jurisdiction. The proposed regulations say people can file complaints whenever, and we will take that under advisement, which is critical for things like Larry Nassar situations, graduate students who don't want to bring up a complaint against their dissertation advisor while they're in school. This is a huge recognition, and I think a great move by OCR. To open that avenue to allow us to take complaints, even if someone is not actively participating at the time they filed the complaint. I never understood that restriction. And frankly, I'm glad to see us go back to one that makes more sense.
Any other final thoughts from our panelists? All right.
Just
Well,
stick with us. Just
Yeah.
stick with us. We're continuing to puzzle through a lot of this, and we'll just keep trying to get good information out to you so you can get prepared.
We're going to be doing a lot of events coming up. We try to make a lot of them publicly accessible like this one, but a lot of them are going to be members only, which hopefully is an impetus for those of you who are participating today who aren't a part of the TICSA community to get involved, because we're not going to keep all the good stuff behind the paywall, but a lot of it we are.
True. And, to further that, Brett, the ATICSA community is, over 8,600 strong. So to have all of those Title IX coordinators and Title IX professionals there with you as well, kind of holding your hand across the, across the river of doom, absolutely helps.
And Meg, I don't know if this is you or another colleague, if folks were interested in potentially seeking a TICSA membership and aren't currently, how would they do that? Can someone post that information in the chat?
Yeah, I did put it in the chat, but feel free to also go to our website and click on Become a Member, and we can walk you through that. If you do want a little sneak peek of what membership provides you at all 3 of our levels, we can also set a Zoom with you so we can kind of walk you through it and show how many inclusions and benefits that not only the regs process has for you, but all times. So thank you to our panelists for their super speedy read of the 2022 proposed regulations. The recording will be placed in your ATICSA event lobby within 24 hours, and I strongly encourage you to bookmark our website at atixsa.org/regs for all of the upcoming items that we have that everyone spoke to. Thank you so much. Goodbye.
Thanks, everybody. Great to see you.
I'm just going to say